If you've been sued by a debt collector, do you know how to get the court to dismiss your case? I'm going to teach you how. The thing that you need to do is know how to file a motion. Now, a motion is just a formal request for a court order. Motions can take two forms. They can be written or they can be oral. Now, oral motions are usually only made when you're in court in front of the judge, like at a hearing or a trial. So the kind of motion that I'm going to teach you about today is a written motion. Now, a motion, you just put it on a pleading form. Now, if you head to debtbrief.com, and you can check out the link in the description, we've got forms there for sale, including motion forms that you can use to create a motion and file it in your own case to ask the judge to dismiss your case. Now, what you want to do on this form is you've got to put your motion in a specific format. And this is the kind of format that they teach you in law school. So your motion will have four things in it. Number one, you want to have the request. That's the thing that you're asking the court to do. If you're trying to get the case dismissed, you're going to say that you are making a motion to dismiss the case. Number two, you want to have the facts of your case. Now, a common motion that you might file is a motion to dismiss because the statute of limitations has run. So the facts might be, this is when the debt was incurred, this is when the case was filed. The third thing that you want to include in your motion is the law. So if you're doing a motion to dismiss based on the statute of limitations, the law would be what the statute of limitations is. And then you're going to cite to the law that tells us what the statute of limitations is. The fourth thing that you want to include in your motion is how the law applies to the facts of your case. So if we continue on with our example of a motion to dismiss based on the statute of limitations, you're going to say, well, the debt collection lawsuit was filed on this date, but the debt was incurred on this date. The statute of limitations is 6 years. The time period that's elapsed between these two items is more than 6 years. So the debt collector has exceeded the statute of limitations in filing this lawsuit, so the court should dismiss the case. It's really that simple. Now, of course, you have to have the facts and the law on your side to get a motion granted. But as far as filling out a motion and getting one filed, it really is that easy. Now, once you have completed your motion, you're going to file it with the court and send a copy to the other side. They've usually got about 2 weeks. That timeline is going to vary based on your state, but they've usually got about 2 weeks to oppose your motion and respond. If they don't respond, great. You just ask the court to grant the motion, tell the court that it's not opposed, and the court will likely grant the motion. Now, more likely than not, your debt collector is going to oppose the motion. At that point, you'll ask the court to make a decision on your motion, and the court will weigh both sides and decide if he's going to dismiss your case or not. Now, there are a few types of motions that are common in debt collection cases that debtors or defendants can file to try and get their case dismissed. The first is a motion to dismiss. You're going to file this right at the outset of the case. This means the other side can't possibly make a claim because there's some reason that prohibits a claim. For example, the debt has exceeded the statute of limitations, or number two, they've filed the lawsuit against the wrong person. You're not the person who has incurred the debt, or there could be other reasons why the case should be thrown out right away. Another motion that you can file is a motion to arbitrate. Now, this is more common in cases where there's like medical debt or credit card debt, where your original written agreement, your original signed contract, includes an arbitration agreement. Now, in that case, you're going to file a motion to arbitrate or a motion to dismiss and send the case to arbitration and tell the judge this case should not be in court because the parties signed an agreement to arbitrate. So we're asking the court to dismiss the case so that the parties can arbitrate instead of litigate in court. Now, a lot of times, third-party debt collectors that buy these debts, they don't want to go to arbitration. The reason for that is it's going to cost them because in arbitration, the parties have to pay an arbitrator or a panel of arbitrators to decide the case rather than have a judge in a court who's going to do that for free because our taxes pay for that. So they don't want to go to arbitration. It's going to cost them more money. And if the debt's small, it financially doesn't even make sense for them to arbitrate. So if you can get the case dismissed and sent to arbitration, there's a pretty good chance, especially if it's a smaller debt, that the case is just going to be dismissed altogether and the debt collector won't pursue it any further. Now, the third type of motion that's common for a debtor to file in a debt collection case is a motion for summary judgment. This is really similar to a motion to dismiss, but it requires you gathering the facts of the case during the case before you file that motion for summary judgment. And this may mean, you've obtained information from the creditor or from the debt collector during the case, and now you're ready to tell the judge, hey, they don't have a case here, or they don't have enough information. Now, where you can do this is if you send written discovery requests to them that they don't answer, or you send a written discovery request to them and say, hey, produce the information you have that proves that I owe the debt. And if it's a third-party debt collector, that proves that you own the rights to collect on the debt. And if they can't produce that information, you file a motion for summary judgment that asks the court to dismiss the case because they have the burden of proof and they have not proven that you owe the debt or that they own the debt. So those are the three types of motions that are really common and that you can use to get your case dismissed. Now, if you need a form, you don't really know what you're doing, we've got you covered. Head to debtbrief.com or check out the link in the description. You can get a form motion there. It comes with our forms pack with other forms that you can use as well. And we can help you out there. Also, if you want to meet with me and have a video call where I teach you specifically how to write a motion, and it can be a specific to your case, like a motion to dismiss, or if you need a motion for summary judgment, I can teach you how to write a motion to dismiss, or a motion for summary judgment, or a motion to arbitrate. Just send me an email, contact@debtbrief.com. I'll include that email down in the description as well. If you shoot me an email, we can set up a video call and I can teach you how to do that. Finally, if you're in a debt collection case and you feel like the debt collector has violated the Fair Debt Collection Practices Act or has done something shady, you may have the ability to actually file a counter lawsuit against them. So if you think that might be the case, shoot me an email again at contact@debtbrief.com and I will help get you a referral to a local lawyer in your area who can maybe take a look at your case and see if a lawsuit can be filed. Those are usually filed at no cost to you. And for each violation of the Fair Debt Collection Practices Act, you may be entitled to $1,000. Likewise, if you are in a debt collection lawsuit or have a lot of debt and you feel like bankruptcy is the best course of action, shoot me an email at contact@debtbrief.com and I can get you a referral to a bankruptcy lawyer in your area that can take a look at your case and determine if bankruptcy might be the right way to handle your debt collection lawsuit. So check this stuff out. Head to debtbrief.com. We've got a lot of resources there. We've got a blog post specifically about motions and how you draft them that may be able to help you out as well. So look forward to talking to you and seeing you there.